In this session, we're going to cover the book entitles it Employment Contracts, and that is part of this chapter, but we're also going to cover general principles that apply and are important in the business relationship. So some of these things, if you think of, you hear of HR, human resources, this chapter and then the next chapter that we cover this week are going to deal with laws and rules that really are things that are going to fall more into the hands of HR. So to begin the chapter, let's talk about the employment at will doctrine. We've talked about the relationship when we talked about agency principles of you have employees and you have independent contractors. Well, when we're talking about employment at will, we're talking about employees. Independent contractors don't have that employment relationship. So the prevailing rule is that an employee-employer relationship is at will. And when we say at will, that's the legal term of art that means that the employment relationship can be terminated by either party at any time for any reason. So you take the common example of a child who's in high school, a 16-year-old student, goes and gets a job at Taco Bell. At Taco Bell, his employment is at will because that student can quit if he decides he doesn't like it. He can quit because um, he loves it, but he's got to focus on sports. He can quit for any reason. He can quit at any time, and not only he can terminate that relationship, but Taco Bell can terminate that relationship as well because they find that he's doing a bad job, or they just don't like him, or they need somebody who can work better hours than he can. All of those are reasons for which they could terminate him. But it could be for a good reason, a bad reason, or no reason at all. So there's no good cause requirement. You don't have to show, well, we have a good, legitimate reason for terminating him. The relationship in an at-will setting can be terminated at any time for any reason by any party. There's no notice requirement. Now, when I say that there's no notice requirement, that doesn't mean that you don't turn in your 2-week notice and you do it. You just don't have to give them a written notice or any requirement. There's no specific method of notice that has to be given. Now, it's admirable to still give a 2-week notice and to work 2 weeks, but it's not required. And there are often times in the setting where the employer is fine with you not working 2 weeks or you working even less time than that. But there's no hard and fast rule that requires that there be any specific notice that's given. Now we talk about this employment at will being terminable by either party at any time for any reason. That's not always the case. There are exceptions to the employment at will doctrine, and we'll talk about those in just a second. So employment at will can be altered by the parties. This is what I'm meaning by that is this is where we're getting into these exceptions. So the most best example that we can talk about, the easiest example, is an employment contract. We just said that employment at will means that it's, there's no express time to it, there's no express basis upon which you could be terminated. And so those things are, it's indefinite employment that can be terminated at any time for any reason. In an employment contract, you change all that. And so in an employment contract, there's a guarantee of employment for a specific period of time. And they usually explain when and how the relationship can be terminated. So those characteristics that are essential to defining an at-will relationship are altered and not present in the employment contract. Because in the employment contract, you agree to work for ABC Corporation for a set number of years at a set salary, and then you'll have a provision that would say the certain terms and conditions upon which that employment relationship can be terminated. It may give the employer the opportunity to terminate the relationship for good cause, which may be something such as embezzling money or fighting another employee. Those would be things that would likely qualify as good cause and allow the employer to terminate that agreement. The same way the employee may have the opportunity to terminate the agreement upon a specific period of time of notice. And you may have a provision in the contract that would require a payment of some form of compensation if it's terminated within so short of a time period. So, for example, contracts will occasionally have a provision that says if you leave within the first, say, 12 months or 18 months, you have to pay a certain percentage or fee back to the employer, and it's intended to entice the employee to remain for at least longer than that 12 or 18-month period. But the employment contract alters that at will, the important characteristics of the at will relationship, because the employment is for a set duration and there are set terms of when that relationship may be terminated. And if it's terminated, a lot of times there's a requirement of a payment of severance, especially when it's the employer that's terminating the relationship and they're doing so without good cause. The severance agreement may be to pay for 2 months, it could be to pay for up to a year. Employment at will. Even though you have no express agreement, the parties may still find that there's an implied employment contract. So even if you don't have the express employment contract that's been executed, the parties could still have an implied employment contract based on their conduct or the terms that could be found in something such as a handbook. So some factors that you would consider here are one, has the individual been a long-term employee? Has the employee never been formally criticized or warned about his or her conduct? Has the employee received raises, bonuses, and promotions throughout their career? Has the employee been assured that his or her employment would continue if they did a good job, or that the company did not terminate employees at the same level except for good cause? And has the employee been assured by management that he or she was doing a good job? If some of these factors are present, it'll help you to determine whether there is an implied employment contract between the parties, despite there being no express agreement. So we talked about the implied nature of the employment relationship can be found through the terms in a personnel manual or a handbook. And so if you have policies and terms in your handbook or personnel manual that they contain sufficient terms that indicate an intent to create employment relationships, that could be sufficient to establish an implied employment contract. So from the standpoint of the employer and giving some advice or guidance to the employers, the handbook and personnel manual, to avoid them finding an implied employment relationship, should state things such as it is not an employment agreement. It should state that the employment is at will for its employees. It should also say that the employer has the right to unilaterally change the handbook or manual at any time. Although these aren't dispositive, these are all pieces to the employment or to the handbook or personnel manual that's going to show a lack of an intent for the terms of the handbook or manual to bind the employer and employee into a employment contract. So if you're saying that's not an employment contract, then that negates an intent of creating one. Also, if you define the relationship as being at will, that again evinces an intent to not have an employment contract. And lastly, if the employer has the right to unilaterally change the handbook terms, then that is not indicative of a contract, because in a contract the terms are bound. But by reserving that right to unilaterally change it, meaning that there's got to be no agreement by the employee, no meeting of the minds on the terms of the relationship, that indicates that there's not a contract being formed. There are also public policy exceptions to the employment at will employment at will doctrine. So we talked about employment at will as the default rule, It can be altered by an employment contract, whether it's an express one or an implied one. And public policy is another way that this employment at will relationship is altered. And so what we're talking about when we say public policy exceptions is we're really referring to certain reasons that the law has said an employee may not be fired. So in other words, when we say with the employment at will, you can usually terminate them for any reason at any time by any party. Uh, this public policy reasons are instances in which that relationship cannot be terminated for any reason. And if the employee is terminated for one of these prohibited reasons, we'll see those on the next slide, then the employer would be liable for wrongful termination, wrongful discharge. The cause of action in most states is referred to as it would be a retaliatory discharge claim. So what are some of the reasons, the public policy reasons, that the employment at will relationship may not be terminated? One is, we'll talk about this in our next session, but the law has recognized uh, protected classes, protected classifications. These are things such as age, race, religion, disability. It's if you cannot terminate somebody because of their age. You can't terminate them because you think they're too old. You can't terminate them because they're female. You can't terminate them because of their race. You can't terminate them because of some religion or disability that they have. So these are reasons, public policy reasons, that the law has said it's illegal for you to terminate someone. And we'll talk more about Title VII and the Age and Discrimination in Employment Act, the Americans with Disabilities Act. We'll talk about those in our next session. But that is one basis in which public policy has said you can't terminate an at-will employee because of one of these legally protected classes. So it's against the law to terminate someone, even an at-will employee, because of a protected classification such as their race or age. Another time in which public policy reason in which you cannot terminate an at-will employee is you can't terminate a person because he or she has filed a workers' compensation claim. If you do, you're going to be subject to a retaliatory discharge claim. Tennessee has recognized this. A majority of states have recognized filing a workers' compensation claim as a public policy reason to prohibit, not prohibit, but to alter the employment at will relationship. So when we say you can't terminate, you can terminate for any reason. The reason of terminating for filing a workers' compensation claim is a prohibited reason, and you would be subject to a retaliatory discharge claim. And another category is terminating a person because he or she has refused to remain silent about an illegal activity, or they refuse to participate in an illegal activity. And this goes to a lot of the claims that you hear of as referred to as whistleblower claims. That's what it's saying. You can't terminate somebody because they're speaking out against an illegal activity, blowing the whistle. You can't terminate them because they refuse to participate in the illegal activity. And that refusal, again, maybe through the form of blowing the whistle, of refusing to participate in something and taking a stand for it. So these are all reasons, public policy reasons. These are terms upon which a employer cannot terminate an at-will employee. If they do, they're going to be subject to a retaliatory discharge claim. Non-compete agreements are probably something that you're familiar with. You've probably heard of a non-compete agreement. Some of you may have even signed non-compete agreements in your employment. A non-compete agreement is an agreement in which the employee agrees to not work in competition with his or her employer, her current employer, after the employment relationship ends. These agreements often have prohibitions on direct competition, meaning you can't go work in direct competition with your employer. They prohibit you from using your employer's trade secrets to your advantage and their disadvantage. And they usually prohibit the solicitation of clients and or other current employees. So it's meant to uh, prohibit you from being able to go and uh, call on former clients to take away their clients. It also will prohibit you from being able to go and again solicit their top salesman or their top engineer, their top accountant. Um, so these agreements will try to limit the damage that you can do as a former employee to your current employer or to your former employer. It's also common to have a confidentiality provision in these agreements that would prohibit you from disclosing or otherwise using any of the confidential information that you may have obtained from the former employer in either a new employment or just in general from disclosing it to someone else. And so these things that would be covered as confidential information would be things such as like client list, pricing guides, design manuals, anything like that that's going to qualify as something that would be protected. Financial records would fall within that. Those are going to be things that are going to be subject to the confidentiality provision, as well as many of those things may qualify as trade secrets and be protected under that basis as well. So non-compete agreements are really designed, if you look at the things that it prohibits, is it's definitely designed in favor of the employer's economic interest. It's intended to protect the employer. Uh, on the flip side of that, it in turn harms or at least impedes an employee's economic opportunities. If an employee has worked his whole time in the say car paint industry and he's now precluded from working in the car paint industry, it may significantly harm his economic ability to make a living and provide for him and his family. So non-compete agreements, since they're usually slanted in favor of the employer and protecting the employer's economic interest, most states disfavor non-compete agreements. Now, the law on non-competes varies from state to state. This is a state law-based area. This is not something there's not federal law on non-compete agreements. So you got to look at what the state says. And most states disfavor non-compete agreements because they see them as a restriction on trade and an employee's ability to make a livelihood. And for those reasons, they're disfavored, but they will be enforced when the terms are reasonable. And so courts will often not uphold these agreements across the board. A lot of times they will analyze the agreements to make sure that they're reasonable and as least restrictive as possible to both protect the employer, to protect their economic interests, but to not harm more than it has to the employee. And so when we say they're looking to see that they are reasonable in terms, we're looking at the scope of the activities. If you've got to limit the prohibited competition to the area in which the person really worked. So the example that we gave of the gentleman who had worked in the car paint industry, if you limit the scope of the non-compete to him directly competing only in the car paint industry, that's more reasonable in scope. But if you prohibit him from working in the car industry at all, meaning that he couldn't work for AutoZone or somewhere selling auto parts, even though that's not in direct competition with what he had done previously for his employer, that could be found to be too restrictive. That's not reasonable in the scope of the activities. So it could be that instance could be narrowly tailored by the court that they would only enforce the non-compete agreement against direct competition in the car paint industry, but they would allow the person to work in the auto parts industry. when we talk about duration, we're talking about time period. We don't want it to be overly restrictive in the amount of time that the former employee is prohibited from working in that industry. So this is a facts and circumstances decision, and it just varies from case to case. But in Tennessee, there's an example where it's been just the duration of the non-compete has been just a few months, all the way up to 3 to 5 years. And again, it depends on the facts and circumstances of the case. There's no bright line objective rule, but you want it to try to be as limited in duration as possible. And so usually 1 to 2 years is a good rule of thumb. I would encourage an employer to not write it any longer than 3 years. And the last element that you look at, or the last term, is the geographic territory. Are you restricting the former employee from working in the area in which you have business? So, or even beyond that, where they had previously worked. So if the gentleman who sold car paint sold it in just West Tennessee, a provision that restricts him from selling car paint in the entire state of Tennessee or in the entire United States or the Southeast, any of those are going to be more restrictive than is necessary, than is reasonable, because he's not in those areas competing. Now, if the car, if his former employer in the car paint industry, if they did work and sold throughout all of Tennessee, then there'd be a stronger argument for the scope of Tennessee being reasonable. But if they did only sell products in Tennessee and they tried to prevent him from selling anywhere in the Southeast, that would be found more than likely to be too restrictive. So you've got to look at protecting the employee. It's a balancing act of providing some protection to the employer, but not unfairly or unduly restricting the employee's ability to find a job and make a living. And so it's a balancing act that the court will take and decide on a case by case basis. Another area that comes up is employment references. So it's not uncommon for an employee to leave uh, employment and to seek a job somewhere else, and the prospective employer want to find out, well, how did this applicant perform at his prior job or prior jobs? And so the prospective employers will commonly call the employer and ask for a reference about the applicant's job performance. So uh, in this instance, it's commonly recommended, and the common practice is to provide a neutral reference. A neutral reference may be something to the extent of Susie worked here from this date to this date as a sales clerk, and that's all you provide. That's a neutral reference. Um, the reason, as we'll talk in a minute, for the neutral reference is the potential for legal liability. And so here, that's why it makes it important to have a written policy so that your employees know how to handle employment references. And it's important that they know how to handle them, but that they're also handled universally the same, so that there's a uniform policy on how you respond to a request for an employment reference. So we talked about the neutral policies of just confirming dates worked and sales or in position can have legal risk. So on one hand, if the former employer, if you actually provide an answer um, that's more than just the neutral, then you may have where the prospective employer will refuse to hire the applicant, your former employee. If that happens, the employee may sue you uh, based on a lost job opportunities. I've got a case that I've been defending recently in which that is exactly what they said. The employee was terminated for misconduct when the former employer got a request for a reference, they told them of the uh, misconduct, and the prospective employer refused to hire the applicant. And so the applicant slash former employee sued our client. And so in that scenario, that's an example of where there could be legal risk for providing more than a neutral reference. At the same time, this didn't happen in our case, but it's possible that when you have provided something beyond the neutral reference, the employee could say that you defamed him or her, that they could sue you for defamation. But remember that when we talked about the defamation claims in week 4, that truth is a defense to a defamation claim. So when you give your references, if you are going to say something more than a neutral reference, try to be as truthful as possible. Always try to tell the truth, but try to be as truthful as possible. And I know that that would always be the intent, but it is possible that you could have misunderstood something based on the investigation, or you may have been told something wrong by somebody. So it is possible that your understanding of what happened, what made up the basis for terminating the person, the misconduct or whatever happened, in fact was not as egregious as you believed. But if you are going to tell more than than a neutral reference, try to be as truthful as you can. But on the other hand, an employer could have liability if all they do is provide a neutral reference. And so if you only provide a neutral reference, but there is some serious issue out there, so let's say it's the setting of a nursing home that's trying to hire your former employee, and you fired the employee for um, abusing a resident. That would be a significant issue, one that could subject that prospective employer to liability if the applicant is hired and commits abuse again. In those scenarios, they may be sued for a negligent hiring theory, and the new employer may in turn point the finger at the former employer saying, they didn't tell us this. Again, this is a type case that's based on a negligence theory. Both these negligence type theories that we've talked about are not as widely accepted, at least at the current day. They may become more common, and there may be more law accepting those type claims, but it is a type claim to be aware of, because any plaintiff can make these type arguments, and by making these type arguments, the employer would be potentially subject to liability.